Hello boys and girls, today we're going to be reviewing the court system. So to begin with our objectives, we're going to be looking at four main points today. We're going to be looking at how the United States has a dual court system, which consists of state courts and federal courts. We will also be looking at the power of judicial review and how it is an important check on the legislative and executive branches of government. We will also look and see how the courts resolve two kinds of conflicts, civil and criminal. And lastly, we'll look at how the right to due process of law is outlined in the 5th and 14th Amendments to the Constitution of the United States. So let's get started, and we'll start taking down notes about the dual court system that exists in our country. So to begin here, the United States again has a dual court system, which consists of state courts and federal courts. Both are going to have their own system. So federal courts have something called jurisdiction over federal laws. And I'll give you the definition for jurisdiction in just a minute. But for the most part, federal courts are only going to deal with any kind of laws or any kind of cases that are going to be on a federal level or beyond a state level. So the next court system is the state courts, and state courts have jurisdiction over state laws. They don't have any jurisdiction over any kind of federal laws, although laws that exist in a state may be existing on a federal level because of the whole concept of federalism and how the states have to adhere to the United States Constitution. So the main role of the judicial branch is to interpret laws. So when we're talking about interpreting laws, it's not so much that we're translating from another language or translating a message, but we're trying to take the laws that currently exist on a federal or on a state level and apply them to the particular cases that are presented to a judge and a jury, or simply to a judge. So important terms to know going forward in reviewing the courts and in our SOL review today. We're going to be looking at the first word, which is jurisdiction. So this is the authority to hear a case. So when we talk about jurisdiction, we're really saying, okay, if you commit a certain crime, where are you going to go in the United States courts? Are you going to land in the state court, or are you going to land in federal court? If you commit a crime that only takes place in a state, like for example the state of Virginia, you will go to a state court. If you commit a crime and that crime is committed in multiple states, let's say a crime is committed in Virginia and North Carolina and South Carolina, you would go to a federal court since you committed a crime in more than one jurisdiction. So there's a couple of different kinds of jurisdictions. We have original jurisdiction, which is the authority to hear a case first, and we'll look at a couple of different courts and see which one has authority to hear a case first. For the most part, those are the lower level of courts in both the state and federal systems. The next kind of jurisdiction we have here is appellate jurisdiction. So this is the authority to review a decision of a lower court. Now, in both the federal and the state level, there are courts that only have appellate jurisdiction. There actually are both, in both the federal and the state, a court of appeals that exists. And those courts would have appellate jurisdiction over a case. So there's also two kinds of crimes that people can commit. The first one here is a felony. This is a serious crime. This is a crime that would involve something of a violent nature, for example, murder or a theft of a large amount. There's also another kind of crime, and that crime is going to be a misdemeanor. That would be for a smaller or less serious offense. So a misdemeanor could be something like a reckless driving, or riding a train without a ticket, or some kind of petty theft, for example. So that's pretty much the first point we'll go look at. So now we're going to move on to our second point. So the United States has a court system whose organization and jurisdiction are derived from the Constitution. So there are a number of different courts here, and the first one I'd like you to make note of here is the Supreme Court. So this is the highest level of court in the land, and as it says here, there are justices, of which there are 9 justices. There's no jury, they have appellate jurisdiction, and they have limited original jurisdiction. And if you think about where their limited original jurisdiction would exist, it is in the check and balance of the president, which is the executive branch of the national government, and of the House and the Senate, with the that represent the legislative branch of the national government. The next level of federal courts is the Court of Appeals. So the Court of Appeals simply has judges, just like the Supreme Court. There's no jury, and again, they have appellate jurisdiction. So the next level of court in the federal side would be the district court, and this is consisting of a judge, and it may have or may have not a jury. This is the only federal court that has original jurisdiction in just about every single kind of case. So if you look at the federal courts and kind of how they're structured, so we have Supreme, we have Appeals, and we have District. The first letter of each of these courts would be S, A, and D. So you could say the federal courts are SAD to help you remember. So the federal courts would be SAD because Supreme, Appeals, and District. Let's move on to the next point here. Virginia, like each of the other 49 states, has its own separate court system whose organization and jurisdiction are derived from Virginia's Constitution and state laws. So Virginia has its own court structure. It's going to have an additional court if you compare it to the federal court. So the federal court has 3 levels, and the state of Virginia is going to have 4 different levels of court. So the highest level of court in Virginia, you probably remember this from working on our courts unit, is the Supreme Court. So just like the federal court, there's justices, there's no jury, there's appellate jurisdiction, and there's limited original jurisdiction. So think about it. Where would the limited original jurisdiction be for the Supreme Court? It would be to check the executive branch of the state government, which would be the governor, and also to check the legislative branch of the state government, which would be the General Assembly. The next level of court in Virginia would be the Court of Appeals. So again, this does not have a jury, it simply has judges. It has appellate jurisdiction to review decisions of the lower level circuit courts. So there you go. The next level is going to be the circuit court. So this is a judge, and it may or may not have a jury, depending on the crime and depending on how the case goes. So this would have original jurisdiction for felony cases and for certain civil cases. Also appellate jurisdiction from district courts. So if you committed a felony in the state of Virginia, you would start straight away in circuit court. You would not start in another court. The last levels of court here in Virginia are going to be the General District Court and Juvenile and Domestic Relations Court. So on this level, you would have judge. There really would not be a jury for the most part, and this would have original jurisdiction for misdemeanors, as well as civil cases involving lower dollar amounts. I believe it's dollar amounts below $15,000. So if there was a higher amount, it would start in the circuit court. So the state courts, obviously there's 4 levels, and if you look at the first letters of the 4 letters, we have S, we have A, we have C, we have a D, J. So the state courts, you could say, are a SAC DJ. The federal courts would be SAD, and the state courts would be a SAC DJ, for district and juvenile. All right, moving on to our next point here, we have 9B. So if you take a look at the pictures here, you can probably take a guess here what we're going to look at here. It's going to be looking at the federal courts, and it's going to be on this monumental court case called Marbury versus Madison. So the power of the judicial review is a report and check on the legislative and executive branches of the government. So this court case of Marbury versus Madison is going to establish this concept of judicial review. So the whole point about judicial review is that the Supreme Court of the United States and Virginia determine the constitutional laws and acts of the legislative and executive branches of government. So this power is called judicial review. And again, like I said, this comes from the court case of Marbury versus Madison. So this established the principle of judicial review at the national level. So this says that the Constitution of the United States is the supreme law of the land. And the Supreme Court of the United States has a privilege to make sure that the laws that are passed in Congress adhere to the Constitution, and that the actions of the President adhere to the Constitution, and he does not act outside his power. So state laws must also conform to the Virginia and United States constitutions. So this is another way that the Supreme Court can enact judicial review. It can also make sure that the states are acting in accord with the Constitution that they all signed to. So courts, for the most part, are going to resolve two kinds of conflicts. You may already know what these are, but we'll look at civil and criminal. So the first kind of conflict we're going to look at here is a criminal case. So in a criminal case, a court determines whether a person accused of breaking the law is guilty or not guilty of a misdemeanor or a felony. So again, going back to our definitions, a misdemeanor is a lesser crime and a felony is a more severe crime. So we're looking to see how the whole process of a criminal case is broken down. So a person accused of a crime may be arrested if the police have something called probable cause. So this doesn't exactly mean that he or she is 100% guilty of committing a crime, but they probably are, and they're looking to have evidence that would be able to hold them and bring them to trial. So the case would proceed to arraignment, where a probable cause is reviewed, and an attorney may be appointed for the defendant, or the defendant may hire his own attorney, or may actually waive an attorney and decide to represent themselves in court. So during this arraignment, there is a plea entered, and that plea will be either guilty or not guilty. And the case kind of progresses from there. So the accused may be committed to jail or released on bail, depending on the crime committed and depending on how many times this person has committed a crime, would really determine if they go to jail and wait for trial to happen, or if they could be released on bail, which would be where someone could put up money to release them and allow them to go back home and wait for their court date. So the whole point of having bail too is to make sure that they come to trial. So if they're not guilty, they would get that money back, but obviously if they're guilty, that money would stay with the court. So in a felony case, a preliminary hearing is conducted to see if there's a probable cause. So if a probable cause is determined, a grand jury will determine if there is enough evidence to indict the accused. So the jury would be those people who are selected for jury duty, and they would decide if they are set for trial, or if there's not enough evidence, then they could be released. So in a misdemeanor case, which would be a lesser crime, there's no preliminary hearing or grand jury, you just simply have a trial date set. So in this case, you would just go to the court date and a trial is conducted. And once the trial is conducted, you'd have your verdict, which would be guilty or not guilty. And depending on the outcome of the case, really if the case would end in a guilty verdict, the person would have the option to appeal the case if they would so desire, and if they feel that they would be able to be successful in a higher level of court. So again, in the state of Virginia, if you had a criminal case, you would start in the circuit court. If you had a misdemeanor, you would start in the district court. Or if you were below the age of 18, you may start in a juvenile court. So in a civil case, this would be the next procedure we're going to look at. Again, in a civil case, a court settles something called a disagreement or a dispute excuse me, between two parties to recover damages or receive compensation. So the procedure for civil cases is not quite as intensive as a criminal case. There's less steps because there hasn't been a crime committed. You're simply trying to resolve a dispute between two different parties. So the plaintiff would file a complaint or recover damages to receive compensation. So a case is heard by a judge or a jury, and it can be either one depending on the gravity of the case and the different parties involved. So once the case goes on, there's going to be a ruling, and depending on whether or not the ruling is satisfactory for the plaintiff, cases can be appealed to a higher level court if the outcome isn't exactly what they had hoped for to settle a disagreement, or if they think they could get a better ruling in a higher level of court. So moving on to the next point here. We're just about done for today, but we just have a couple slides left. So this last point here really goes along with two big amendments, the 5th and the 14th. So we're looking at due process and how this process is outlined in, again, our 5th and 14th Amendments to, you guessed it, the Constitution of the United States. So what these two amendments are saying and what they guarantee for us as citizens is we have due process of law, which protects us against unfair governmental actions and laws. So looking at these two illustrations here on the left, the Fifth Amendment is also known as, or commonly known as, your Miranda rights. So, as this diagram showing a police officer is arresting someone. So this police officer is reading or reciting his Miranda rights. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have a right to attorney, and the other things you have. So it's really just to make sure that people know that they are preparing for court, and they should definitely be aware of what they're doing every step of the way. Also, you need to protect against any kind of unfair governmental actions. This is a bit of a joke. As this justice here is saying, as we're running late for lunch, I'm going to dispense with the case for defense and go straight to sentencing. A bit exaggerated, and this would never happen, but just to give you an idea that, in the court of law, something like this could never happen. You have a right to have your case heard by the judge or by the judge and the jury. So to finish things up, we have our due process of law, and that's defined as the constitutional protection against unfair governmental actions and laws. So you have a right to a trial, you have a right to a lawyer, you have a right to everything that's guaranteed you're under the law. So due process protections are really separated in these two ways. The Fifth Amendment prohibits the national government from violating due process, and the 14th Amendment is going to prohibit the state and local governments from violating due process. So, and the last point here is the Supreme Court has extended the guarantees of the Bill of Rights based on the Due Process Clause. So the Supreme Court will make sure that everything is honored on both the federal and state level to make sure that you are fairly and justly treated through the court of law. So just a few questions to wrap up here. If I was there with you, I would actually ask you all these questions, but just to make sure we all got our main points down. So the United States has a dual court system, which consists of which two courts? We have state and federal. So how are the two court systems structured? Well, they're structured in the following way. The federal courts are SAD. So the federal courts have a Supreme Court a court of appeals, and a district court. And the state courts have a SAC with a DJ. And so that means that they have a Supreme Court, they have a court of appeals, they have a circuit court, they have a district court, and they also have a juvenile court. The power of judicial review is an important checks with which two branches of government. So it's going to check on the national level, it's going to check the executive branch, and it's going to check the legislative branch. And the court case to establish this judicial review is Marbury versus Madison. So an important thing to remember is that the federal court, the Supreme Court, they like M&Ms. They like to have Marbury versus Madison because that is going to establish that the supreme law of the land is going to be the Constitution. Courts are going to resolve two kinds of conflicts. They're going to resolve both criminal and civil conflicts. And depending on how many different levels or how many different times people are going to appeal the case is where the case will go. The right to due process of law is outlined in the 5th and the 14th Amendments to the Constitution. The 5th is going to make sure that the national level honors all of your due process rights, and the 14th is going to make sure that the state and local levels are going to honor all of your due process rights. And then finally, what do each of these amendments say about the rights of due process? As we said in the last slide here, it's going to guarantee that you are going to have these rights in court and nothing can take them away. So again, if you missed anything in this presentation, feel free to rewind and go back and revisit other slides. Please make sure your notes are filled in. And since you've finished this portion of the lesson, you can go back to Google Classroom and take a look at the next agenda item. So thank you for your time and attention today, and I look forward to seeing you next class. Thanks.